If you have sound issues during this webinar, please see the sound issues box just below the chat box. If there is a global sound issue, we will announce it in this chat box. If you are unable to resolve a sound issue you are experiencing, be advised that we are recording this meeting and you can watch it offline after the meeting ends. Again, if there's a global sound issue, we will make an announcement in this chat box. Good morning. Hello, everyone. Welcome to the State Library webinar on legally enforceable patron behavior policies. My name is Cheri Harris, and I am a longtime lawyer, but I am relatively new to library law. However, as we get further into this, we will see that library law overlaps with some other kinds of law. In terms of today's presentation, we will be looking at constitutional law and particularly at First Amendment law. Kara Cleveland is here with me to help me monitor questions. Thank you, Kara.
You're welcome.
Oh, let's see, and we'll go to this. We'll go to the PowerPoint. So we're going to start with a disclaimer, and if you took my legal research webinar, legal research for beginners, I think it was called, or something like that, beginning legal research for librarians maybe, you know already that I can spend a lot of time on the importance of a disclaimer. I'll be quick here, but if you want more detail, you can find my webinar on our archives, so here goes. The goal of this webinar is to provide information about the law, but it should not be construed as legal advice. If you have a legal problem, you should consult with your library's attorney. When you consult with your attorney, that conversation takes place within the context of a lawyer-client relationship. Even when I present this information to a group of people, that does not create a lawyer-client relationship, even if you ask a question and I attempt to answer it. I hope to provide you with some helpful information about how the law applies to libraries in general, but my role is not to apply the law to the specific facts of your situation. Please feel free to ask questions if you have them during my presentation, but also please understand that I can't answer questions that ask for legal advice. So we're going to do a little roadmap of where we're going to go today. We are going to talk about disruptive patron behavior. You know something about that already, I'm guessing. And we probably don't need to spend a whole lot of time there. We're going to touch on why policies and procedures need to be written down, and that should be pretty obvious, but just to drive the point home, I'll throw in a few drafting tips, and then we'll look at two parts to creating legally enforceable patron behavior policies. We'll talk about what we can regulate, and then we'll also talk about how we can regulate it. In what we can regulate, we're going to talk about some of the different areas that your policies cover. Specifically, if the activity you want to regulate is constitutionally protected, usually by the First Amendment, you will need to meet a higher standard to show that the policy is legal. Under how we can regulate it, we'll look at 4 characteristics all of your policies should share, and these are equal enforcement, patron notice, having an appeals process, and reasonable penalties. So they need to be enforced equally by all employees toward all patrons. Your patrons need to be notified of your policies. There should be some sort of process for appeals, and the penalties need to be reasonable in light of the infraction. At the end, we will go over a couple of things that we cannot regulate, and then we should have time left, hopefully, to discuss the sample policy. It's a lot to cover, but we're going to see how far we can get. So here is a little scenario of a disruptive patron. And I have included this particular case, not so much because you need an example, but because I want you to know that your bad days are not that unlike bad days at other libraries, right? So in this scenario, Mr. Clovis, patron complained about Mr. Clovis that he was causing a disruption in the computer lab by loudly detailing his sexual exploits. He used foul language and called another patron names. and he was given a 30-day suspension for engaging in harassing, threatening, or abusive behavior. Security asked him to sign a conduct offense notification form and tried to explain how to appeal the suspension, but Mr. Clovis refused to sign and refused to listen to the explanation and continued to spew abuse. So then he was violating the code of conduct again by refusing to leave the library upon suspension, and for that he was issued a 1-year suspension. Do you know anyone like this? It gets even better. Clovis filed a complaint with the state's Human Rights Commission claiming that he was denied accommodation based on his Christian beliefs. He alleged that the library and staff officials tried to confiscate and destroy his flash drive, but that he managed to stop them by hiding it in his underwear. He also said that the library was trying to poison his food. This is sad, really, because he clearly has some larger issues here. And in fact, as we'll see, many of the cases that are brought challenging library behavior policies are brought by homeless patrons. And I mention that because I think it's important to distinguish that we want to regulate behavior and that we want to be very cautious about penalizing a status such as homelessness. We'll talk about that a little bit more later on. Anyway, in this particular case, the commission found no reasonable basis for Mr. Clovis's claim, and the Court of Appeals said there is no proof that the library discriminated against Clovis on religious grounds. Part of the reason they were able to arrive at that outcome was because the library had documentation of what had happened, had witnesses to testify about what had happened, and Mr. Clovis did not. He just had, what he said had happened. So one important thing that we're going to emphasize several times today is that you must have written policies and procedures. Part of the problem of unwritten policies and procedures is, well, first of all, will people even remember them if they can't actually refer to them? And how will you train your staff on them? Can you possibly ensure that the staff share an understanding of the meaning of the regulations if they've never even read them? And finally, your policies are likely to fail legal scrutiny if they're not written down, because part of due process includes providing notice. So on the plus side, when you have written policies, you're forced to be more specific when you write them down. You can use the written document to train staff, and if the procedure includes step-by-step instructions, that can serve as a checklist for procedures that aren't used very often. Also, as I'm sure you're aware, increasingly libraries are putting their behavior policies online to even more notice to everyone. So a few drafting tips. Good drafting, which is, in my mind, is what the carefully crafted part of this webinar is about. It's simple, it's straightforward, it's easy to understand. It's clear, it's concise, it's consistent. I recommend using active voice when you can, because that shows who's responsible, and it's usually easier to read. And we also recommend that you number the pages as showing the total number, so 3 out of 6 or 10 out of 30, whatever it is, so that people feel secure that they actually have the entire policy in front of them and are not missing any pages. I'm pretty sure you know the difference between policy and procedure. So this is brief, but just that policy is what the rule says or what the library's position is on an activity, and procedure is how that's implemented. Your policy should have a long-term, stable influence on the way things are handled at the library over time, but your procedure can evolve to reflect that changes in personnel, changes in philosophy, or even changes in equipment or technology. Here we just, for clarity, recommend that you avoid using Latin abbreviations and Roman numerals and stick with whole complete words, using for example instead of e.g. or etc. Okay, so a couple of different types of activity that you may wish to regulate include conditions to enter the library, behavior in the library, and illegal activity committed on library premises. And I listed these not in the order that we're going to talk about them, but for this slide in the order that they occur, because you're going to come into the library, you're going to behave however you behave in the library, and then if you're committing illegal activity, it's kind of, that's the flow of the order things happen in, but it's not the order we're going to talk about them in. One thing about each of these categories that you need to know is that we're going to have to look at how these regulations could implicate the right to free speech. And I think this is interesting. So the First Amendment says Congress shall make no law abridging the freedom of speech. Now that's actually an abridged version of the First Amendment because there's more to it, including freedom of religion and the right to assemble. But for our purposes today, the part of the First Amendment that we're looking at says the Congress shall make no law abridging the freedom of speech. Did you know that access to a public library is included in the First Amendment? The First Amendment doesn't actually mention libraries. It doesn't use the word library or even a right to receive information, but courts have recognized these rights. In Kreimer versus Bureau of Police, a Third Circuit case from 1992, the court upheld a library rule that prohibited disruptive behavior, saying that the library is a limited public forum and may refuse service to someone who willfully violates a library policy. So that court described the right to use a public library as the quintessential locus of the receipt of information. How beautiful is that? Did you know that you worked at a quintessential locus of the right to receive information? In Armstrong, the District of Columbia Public Library, the district court in 2001 notes the existence of long-standing precedent supporting plaintiffs' First Amendment right to receive information and ideas, and this right's nexus with access to public libraries. In Doyle versus City of Albuquerque in 2012, the court also noted that the First Amendment included the right to receive information and access to a public library. So courts have found the right to enter a public library is part of the First Amendment protections that the Constitution guarantees to us, the Bill of Rights guarantees to us. So when you are impacting the right to free speech, you can make restrictions that are that require it to be a reasonable time, place, or manner. So hours, library hours, you don't have to be open all the time just because there's a First Amendment right. You can put limits on when people have to be quiet or when they can be a little less quiet. You can impose conditions such as appropriate attire. That's usually going to be acceptable because they don't directly impact the right to receive information. Partly because if a patron is in violation of a dress code violation, if has violated the dress code, they can presumably fix that and come back to the library at another time when they are in compliance with the dress code. But outright bans are much more likely to be found unconstitutional because by definition, an outright ban is not narrowly tailored and it does not leave open alternate channels for communication. So if the First Amendment right is infringed upon, it has to be narrowly tailored to serve a significant government interest and leave open alternate channels for the communication of ideas. So in looking at some of the things you can regulate, examples of behavior. In Kreimer versus Bureau of Police, this language, patrons shall be engaged in activities associated with the use of a public library while in the building. Patrons not engaged in reading, studying, or using library materials shall be required to leave the building. I've seen that language, not just in this case, but in a lot of public library policies in Indiana. So I think you or your attorneys are picking up on that this language has been allowed. And you can say that patrons have to do the things that people do in libraries. You just don't want to make that so narrow that they can't do some of the other things that people are allowed to do in libraries. Anyway, other examples of behavior type regulations would include no eating in carpeted areas, no running in the library building. These types of requirements are not implicating the First Amendment right to enter the library. So they are not held to the higher three-pronged standard. They're They just have to be reasonable and related to the library's mission. So if a behavior policy is challenged in court, the court will ask, is the policy reasonable and does it relate to the library's mission? And because of that, I would suggest that you start by looking at your mission statement when you write your policy, your behavior policy. So some other behavior that has been litigated in Nails v. Kansas City Public Library, a 2015 district court case. A patron lost library privileges for talking loudly on her cell phone in the computer lab and for trying to sell clothes in the library. Let's keep going. Okay, so if you have conditions that a patron must meet to be allowed into the library, and examples of these are hygiene regulations, a patron dress code, these, in order to be valid, need to meet the legal standard of they serve a significant government interest, they're narrowly tailored, and there are ample alternative channels to receive information. Often the court will find that a government interest is served fairly easily. That's not a high bar to reach, but is it narrowly tailored and are there ample alternative channels is often the hitch when libraries lose these behavior policy cases. So, the idea that it serves a significant government interest is a higher bar than just being related to a library's mission, but the government has found a significant interest in protecting library patrons' safety, the safety of all library patrons, not just the individual who may be violating the code. Is the policy narrowly tailored to fit that interest? Requiring patrons to wear a shirt, for example, is pretty narrowly tailored because it's not hard to meet that requirement. It would be a little excessive, perhaps, if you required them to wear a Hawaiian shirt as opposed to just any shirt. And the alternative channel for individuals who violate the dress code, for example, is put a shirt on so you can get into the library. Not wearing a shirt is not a status that an individual cannot avoid, but if it was, then other options for access would need to be considered. Most of the litigants in these cases have been homeless men. Whether or not the conditions have been upheld depends largely on how the policy is worded, whether it's vague or specific, and whether or not it meets that three-pronged legal status. I'd like to ask you to be mindful not to penalize the unfortunate status of homelessness, but focus instead, as we always recommend, on the specific behavior that is disruptive. And when we talk about speech, now we're getting right to the heart of the First Amendment. So, regulations that are time, place, or manner regulations are considered content neutral because they don't say you can talk about this, but you can't talk about that. Regardless of what you're talking about, you can be limited as to when, where, and how you do that talking or receiving of information. Same three-pronged legal standard. There needs to be a significant government interest. It needs to be narrowly tailored, and you need to provide ample alternative channels for receiving information. Just an example of a time regulation would be if you have certain hours at the library that are considered quiet hours. You can do that. You can say from 10 to 12, it's kind of like Adult Swim at a public library. From 10 to 12, everyone's going to be quiet and study or read. And again, from 6 to 8, maybe you're going to have quiet hours, or maybe, good luck trying to have them right after school lets out, but, it's a possibility. So an example of a place restriction would be to have a quiet room and say that you can say people can't talk in the quiet room. And an example of manner would be if the behavior was restricted, the talking behavior in a library was restricted by a regulation that said something like no shouting. So those are the examples of time, place, and manner restrictions. I have listed 3 exceptions. Speech that is not protected includes child pornography, obscenity, which is not the same thing as pornography, and material that is harmful to minors. So just to be aware that the court is not going to be as sensitive to trying to regulate those things. You can say that a person is not allowed to view child pornography on a public computer at a library without violating somebody's First Amendment rights, because they don't have a First Amendment right to that. Okay, I see the question, what constitutes material harmful to minors? There is a statute that outlines that specifically, and that statute is IC 3549-2-2, and it's just basically the same definition pretty much as obscene matter, except it's applied to a child instead of adult. So let's see. Matter or performance is harmful to minors for the purposes of this article if it describes or represents in any form nudity, sexual conduct, sexual excitement, or sadomasochistic abuse. Considered as a whole, it appeals to the prurient interest in sex of minors. I'm not sure I understand at all what that item means, really. And it's patently offensive to the prevailing standards in the adult community as a whole as to what is suitable matter for minors, and then that it lacks, on the whole, serious literary, artistic, political, or scientific value for minors. I'd say you don't need to actually, I mean, what you need to know is that that's against the law, so you can prohibit it if you want to, I think. So hopefully that addresses that. Okay. So illegal activity, which we've just mentioned, the point about this is just that the activity is illegal whether you put it in your policy or not. You may want to put it in your policy, you may not want to. Some of the things that would be illegal in a library include smoking, fighting, which we do have a case on disorderly conduct. It wasn't exactly fighting, but it was raising a noisy ruckus and then refusing to leave. In that case, a man was ejected from the library for disorderly conduct and was subsequently charged with trespassing when he refused to leave the property. The court upheld that charge. That was an Indiana case from 2016, but it was an unpublished decision, so we're not supposed to cite it. And public indecency, Glotzbach v. State. In 2003, a male patron was charged with public indecency at an Indiana public library, and the court upheld that charge. So it's still illegal whether you have a policy on that or not. I see there's a question about First Amendment audits, and I'm just going to tell you that I can't answer that question. That might be something to talk to the ALA Committee on Freedom of Intellectual Freedom, yes, I think is what it's called. I don't cover that. I'm just covering the status of the law, and that's a procedure I'm afraid I am not familiar with. So back to what you can regulate. This is just a little summary of what we've already talked about. Different activities that libraries may regulate: behavior, provided it's reasonable and related to the library's mission; conditions to enter the library, such as hygiene or dress code, as long as it is narrowly tailored and a significant government interest and alternative channels are provided. Content neutral speech, you can regulate time, place, and manner with the same three prongs. Content driven speech, don't go there. You don't even want to try that. That is protected by the First Amendment. Illegal activity does not need to be in your policy. So here we're going to talk for a minute about sex offenders as patrons. And the case of Doyle versus City of Albuquerque, we get a fair number of questions about sex offenders. So we're going to take a minute to look at that before we go on. In John Doe versus City of Albuquerque, the Albuquerque mayor signed an executive order creating a system-wide ban on sex offenders in the city's libraries. So I mention that just so you know, this didn't originate with a library director saying, you know, we're just going to get all the sex offenders out of here. It was a mayor's action. But then the library needed to comply with the mayor's executive order and So they went ahead and did restrict sex offenders from the city's libraries. And that type of restriction does impact the protected First Amendment right to receive information. And the library lost this case, even though the court found that libraries have a significant interest in providing a safe environment for library patrons, especially children, meeting the first criteria of important government interest. However, no proof was offered that the sex offender ban was narrowly tailored or that alternate channels of information existed. After losing the case, the mayor issued a new executive order that set aside certain times when sex offenders were allowed in the main branch of the library only and barred them from the library during the remaining open hours. And subsequent New Mexico state legislation prohibited libraries from restricting access to sex offenders at all. And this is just an example of this idea that a complete ban of a group or category of people from public libraries is going to be subject to a constitutional challenge. And to survive that challenge, it would need to meet the three prongs: narrowly tailored, providing alternate access, as well as having an important government interest. The thing about status type offenses is, unlike the behavior offenses where, or for example, the hygiene or clothing related cases, you can't change a status. You can't go home and put on a shirt and no longer be a sex offender. So there's not an alternate route unless you create an alternate access. But a lot of the types of alternatives that you might think of, like say, home delivery of library materials to those patrons who are sex offenders. Home delivery of materials is not considered public access to all the information that the library has. It doesn't give you access to reference materials. It doesn't give you access to local history materials, things that don't circulate. So even that is probably not, isn't necessarily going to withstand a constitutional challenge. It may, but it may not, and it's an expensive thing to find out the hard way. So I am just going to say, if you want to restrict sex offenders' access to your library, you better consult with your library's attorney before you do that. Okay. So characteristics that all well-written policies and procedures are going to share. You want every patron behavior policy that you implement to share the following characteristics. They should be equally enforced. There should be notice to the patron of what the policy is. When there's an infraction, there should be a reasonable penalty and an appeals process. And doing these things makes sure that patrons know what's allowed and what is prohibited. And it also makes sure you have a fair process take place when an infraction is issued. Oh, I think I just went past one. So the first part of equal enforcement is consistency. The library's policies should apply to teenagers in the same way that they apply to board members. Secondly, policies and any implementation guidelines or instructions should be clearly worded. And this is important for two reasons. One is that it helps staff understand how to enforce a policy and what policies, how to enforce a policy. If the language is vague, such as appropriate clothing is required at all time, each of your staff members may have a different idea of what appropriate clothing is. So that clearly worded appears under equal enforcement. It also appears under patron notice, because if it's clearly worded, then a patron can predict whether or not the patron's behavior is going to violate the policy or not. So let's see, patrons need to know how to be compliant, and you can do that both through clear wording that gives them a predictable outcome, and also by handing out copies of your policies and procedures. But you can't hand out a copy of a policy that's not written, and as we've said before, written policies are just really, really important here. Okay, you also want to avoid vagueness and overbreadth. Vagueness leaves too much open to interpretation. For example, the phrase objectionable appearance was considered too vague in Armstrong versus the District of Columbia Public Library in 2001. And an example of overbreadth would be when you have made a policy so narrow that in addition to prohibiting the behavior that you want to prohibit, it also prohibits a lot of desirable behavior. So if you say you have to be reading a book in order to stay in the library, then you have just made it a lot of patrons, a lot of legitimate library behavior not acceptable. You know, are you going to throw out everyone who's reading a newspaper, who's looking for a book, who's asking a reference question or attending a program? And yes, I see the question, should you have copies of policy available for patrons in case they ask for them? Definitely yes. You can have them on your website. You can have printed copies. In fact, we talk about this a little bit later on about the idea that you can give out your behavior policies when you issue a library card. You can give out your computer policies when you let someone have access to the computer. You can post them. A lot of libraries post them on the wall in the lobby or in the appropriate room, just to make sure that there's no question that that information was available, because that's a crucial part. Okay, the Brinkmeier case. This was an unwritten policy, and the court said, we're not automatically going to overturn every case where there's an unwritten policy. However, keep in mind, you're going to have trouble even proving to us that there was a policy if you can't show us a copy of it. So the other issue in this case was they precluded any person who harasses or intimidates other library patrons from being in the library, but there was no limitation on that. It didn't actually say harasses them in the library. So if they're harassed in the bowling alley, are they not allowed in the library anymore? That just didn't make sense. It wasn't well drafted. It wasn't carefully crafted. Okay. And here's a case, Kreimer versus Bureau of Police, with a long description of behavior that you can read there, that is very specific about what all is meant by harassing or annoying others. They use harass, the same word that was used in the previous case where the library lost, but they didn't lose on this one because they defined what they meant by harassing, and they listed out what they meant, singing, talking to others in monologues, behaving in a manner, and they also use this, behaving in a manner which reasonably can be expected to disturb other persons. And the court likes that reasonable person standard because it's not subjective. It doesn't mean this patron was bothered by somebody tapping a pencil on the table, even though most patrons wouldn't be bothered by that. That's not harassment. It's would a reasonable person be bothered by it. So that's what that case stood for on the behavior point. On the hygiene, there was also a hygiene dress code component to this patron behavior policy, which said patrons shall not be permitted to enter the building without a shirt or other covering of their upper bodies or without shoes or other footwear. Patrons whose bodily hygiene is offensive so as to constitute a nuisance to other persons shall be required to leave the building. Well, the library went on this count too, because while the library didn't define the word nuisance in this policy, they did not have to, because nuisance has a legal meaning. And so while keeping someone out of the library because of a hygiene or a dress code problem, it does implicate the First Amendment, that three-prong test applies, but the court found that the library met all three prongs. They had a government interest in not creating a nuisance to other people in the library and allowing people to use the library peacefully without being disrupted by offensive bodily odors. They found that it was narrowly tailored, and they also found that the alternative channel here, since this is not a status offense, in order to gain entry, the person without a shirt just needs to put on a shirt. So that's the alternative channel here. The question, how do you show intent? This doesn't require intent, this particular.
She says on the prior slide.
Oh, let's see. Oh, with the intent to annoy that person. Yeah. You know, I don't think I have a quick answer for you on that. I'm going to keep going, see if we can get through a few more of these. So a hygiene dress code policy that did not fly is one where the policy just used the word objectionable, that a person will be denied entrance if their appearance is objectionable. And then it gave a list of examples, such as barefooted, bare-chested, body odor, filthy clothing, etc. And there's a problem with objectionable, unlike nuisance is not a legally defined term. And there's a lot of things that could be subjective about that. But even more so, the word etc. at the end of that list implies that there are many other things that could be put on that list. And if you have a list that has many other things that can be put on it, that's not clear notice to the patron about what they can and can't do. So that's a problem. And in fact, in this case, there was testimony that there was evidence that the guards frequently contacted the library director to ask whether or not a person's appearance would be considered objectionable. So even the guards didn't know how to regulate this, how to apply this regulation to individual examples of people who came in. So that's a problem. So just to review some of the problem language and some of the better language, courts tend to disapprove of language that depends on interpretation, that does not give patrons notice of what's allowed, or that individual employees may enforce differently. That leeway to interpret it means it's not really a clear notice of what's supposed to happen. Policies without reasonable boundaries, like they don't limit the activity that's prohibited to the library. You know, if smoking's a problem, is it only in the library or can they smoke at home? Okay, examples of phrases that have been considered problematic by the courts, etc., includes but is not limited, objectionable or offensive without a definition. And at the same time, we have some examples of language that courts like. Courts like nuisance, because it has a legal meaning, and there's a cite to Indiana statute that defines nuisance, and here's the actual definition, so you know what that legal meaning is. You don't have to include that language in your policy at all, because that language is brought into the policy just by use of the word nuisance. So injurious to health, indecent, offensive to the senses, an obstruction to the free use of property so as to essentially interfere with the comfortable enjoyment of life or property. Now, this actually comes from the property code, but there is a concept in property of that if somebody has a nuisance going on, and there are some other nuisance terms in the code. There's a common nuisance, and there's, common nuisance is just a place that sells alcohol or drugs, and that's different from this. But anyway, this idea that a nuisance has a meaning, that if your house is so run, meaning from property law, that if you're renting a house and it's so run down that you can't even live there, then probably the landlord is maintaining a nuisance, and that's a problem. So the court also likes behavior that can reasonably be expected to, because that brings in the reasonable person standard that the court likes. Okay, so on the idea of appeals, you need to offer some type of procedure. It doesn't have to be a full-blown court hearing. There's not, a jury is not required, an opportunity to present evidence is not required, but for minor infractions that do not, for short suspensions, you need to at least allow the patron to state their side of what happened, their position on what happened. If there was a reason why what happened that might be understandable, you give them a chance to speak and address the situation. If it's a more severe penalty, then you might give them a little bit more process. It may be that they are able to come to a board meeting. They may be represented by an attorney or someone who speaks on their behalf at that meeting, something a little bit more involved for a longer type of penalty. So reasonable penalties, remember that if you're barring people from the library for life, you've implicated their First Amendment right to receive information. So you would never do a lifetime ban for a first-time minor infraction because that would be disproportionate. But you can increase the penalty for repeated infractions. And for example, the court has upheld a 6-month ban for a patron who gave an offensive note to another patron. And the court took into consideration that longer ban, that it was, instead of being 1 month, it was 6 months. The court took into consideration the fact that the person interfered with another library user's right to use the library. So it's her constitutional right as well. And of course, reasonable penalties should be in writing so that you're providing notice of what those penalties are. Okay. I think in order to get caught up, here, we are going to just skip over a few cases, and they'll be available to you on the PowerPoint, which will be available. And so we're just going to kind of, so these are examples of what kind of processes do. And so, for example, a plaintiff who was barred for 2 years after harassing and staring at a patron was given a right to appeal with legal counsel to the library director, but they didn't say, they thought that wasn't enough. They said they wanted a chance to confront their accuser in a trial by jury, and the court said those rights do not apply to library discipline hearings. So here are some samples of penalty procedures written out that give a little bit of indication of what process is available to a person who violates, and we're going to kind of speed through that. So if it's a bigger punishment, there needs to be more process available to appeal. Appeals are not court hearings. You can increase penalties based on repeat infractions or based on interfering with another librarian's, another patron's right to use the library. Okay, so now we have a couple of areas of law where you can't regulate. There are federal or state laws that prohibit you from regulating these things. Service animals, that's covered by the Americans with Disability Act, so you can't address that. And there was a great webinar just last month called Who Let the Dogs In by Denisha Posey of the Indiana Civil Rights Commission. I learned so much from it. I recommend if you haven't, if you didn't participate in that and you haven't listened to it, you might want to, because it really was a good explanation of what you can and can't do. For example, you can ask what the dog is trained to do, but you can't ask what the patron's disability is. So there's some specific things to know about that I'm not going to go into because it was already covered well. Let's see. I will have a recommendation at the very end. I'm sorry, Jennifer's question. Policies to reference when looking at changing your current policy. I'm going to touch on that at the end. Firearms, I did, Mary Kay Emmerich and I, Mary Kay Emmerich, the director of the Newton County Public Library, and I did a webinar on guns in the library that was recorded on June 29th, 2018, and that is available on the archives now, that goes into detail on this. I will say, again, with firearms, like everything else, regulate the behavior. Don't focus on the weapon itself, but regulate the behavior. You can say that a patron cannot create a safety hazard for themselves or others. You can say that a patron cannot harass, annoy, intimidate, or threaten others. And also just the two exceptions where you can have a policy limiting weapons would be that you can prohibit or restrict intentional displays of firearms at a library's public meeting, and you can prohibit on-duty employees from carrying firearms or having firearms in plain sight on library grounds. However, if you do that, you cannot prohibit an employee from storing firearms out of view in a locked car on library premises. Finally, breastfeeding. This is the breastfeeding statute, and I want to recommend it as a great example of spare drafting. If you read this statute, you know exactly what it means. Notwithstanding any other law, a woman may breastfeed her child anywhere the woman has a right to be. So I just think that's a model of clarity, because it doesn't leave open many questions about how to apply that. So your library cannot forbid breastfeeding. You could encourage breastfeeding in a particular area by setting aside some space just for nursing moms, or creating an area that's particularly conducive to breastfeeding. But even if you do that, you can't force people to only nurse in that nursing area that you've made available. So those are the things you cannot regulate, right? And those asterisks just mean they were covered in recent webinars. Now we're going to talk about a little bit about the sample behavior, and I want to take a quick look at time. We're not going to spend a lot of time on this. The sample policy that I sent out, you need to know that it's not perfect. It is a sample policy, not a model policy. It may not address everything you want in a behavior policy. For example, this is based on the idea of a research facility, and so it doesn't necessarily address things like children must be accompanied by an adult, or whether or not adults can be in the children's area without a child. So there are some things that may be missing from this. What I like about this policy are that it starts with the mission, which, as we talked about earlier, identifying the mission and how the policy relates to the mission is something that courts find helpful. It also gives a reason for the policy in the second paragraph. The third paragraph, this could probably be, you use a more active voice, like instead of saying all briefcases may be subject to inspection, you could say that the library staff and security reserve the right to inspect all briefcases. And that would be a more direct way of saying that. And then, let's see. Okay, this includes, notice that at the end of the list of behaviors that are prohibited, there is not an etc. So that's not vague. It uses the phrase reasonably expected, like we talked about. It adds an additional violation for failure to leave when being asked in 1B. It uses the phrase obscene or abusive language or acts, and obscene is, I think, a defined word in the code also. So, and then it also uses these magic words for hygiene, so offensive as to constitute a nuisance to other persons. It addresses cell phone use, it addresses food and beverage use, it addresses the volume of conversation, audio, patrons using, need to use headphones if they're using audio materials. And then the last paragraph addresses a procedure, which includes notice, suspension, removal, and opportunity to appeal. And if it's a larger suspension of 30 days or more, then the opportunity to appeal is to the library board of trustees. So that's my sample policy that I shared. And there I had access to so many policies when I was trying to write this up that, trying to combine them all would have been a huge feat that I wasn't quite prepared to take on. But I am going to tell you where you can find a bunch of sample policies and examples. First, we've got a little summary of the things you do and don't want to do. Sort of just a summary of what we've covered here, and I'm can see I don't have a lot of time left, so I'm going to let you read that summary and keep going. So here are two resources that I wanted to mention, and this goes back to the question of examples that you can use. The first thing is called Developing and Writing Library Policies and Procedures by Stephen Henson. And honestly, I found this online, but I don't know if it was an open search that I found it on, or if it was in Westlaw, which I also did a lot of research on. So, but it's kind of like a general manual of do's and don'ts and general guide to policy and procedure drafting. The second thing is that on our website, on the ISL's website, and I'm going to tell you two different ways to get there, we have lots and lots of actual public library policies that are in effect in Indiana today. So the way that's set up is that it's libraries that have their policy on their website, and on our website we just have a link to their website so you can see what their policy is. You can get to that page, and we have not just behavior policies, but we have all different kinds of policies. But here's how to find the behavior policies. If you go to our website and then under the menu on the left, choose Services for Libraries, and then you would choose Additional LDO Resources, and then you would choose Public Library Policies, and then one of those is Behavior and Alcohol, Tobacco, and Drugs. And that is, there are, I'm guessing, I can't remember exactly, but maybe 10 different policies, links to 10 different policies there of different size libraries, large and small. Another way to do that is just go to our website, and in the search box, I think if you just search for library policies, that page will come up. So does every offense we ban patrons for have to be specifically included in the code of conduct? So if it's an illegal activity, it doesn't need to be included in the code of conduct, but otherwise, are you warning people that they can't do the thing that they can't, that you want to ban them for? So that notice is important, and there are some ways to bring in broader concepts rather than just having a laundry list, but it should either fall under one of those broader concepts that has a well-known definition that isn't necessarily in the text of your policy. But for example, if somebody becomes violent or if somebody assaults a patron, those are going to fall under the it's already illegal, so you don't have to have that in your policy. I don't know if that helps address your question there. Here is my contact information, and I know I often think of questions after the fact. Just be aware that you are welcome to email me or call me, and that I can do what I can to help you, and that I also will not give you legal advice that should come from your library's attorney. Okay, wow, we got through that pretty well, I think. Let's see. Just gonna give you a minute to see if there are any other questions. I see some typing, so I'll give you a minute there. Oh, good, great. Oh, I'm so happy to see the positive feedback. Thank you so much. You have no idea what positive feedback means to us. It's so much nicer than working in a void and not knowing how things go over. Okay. So I think we are about done here. And if questions come up, you know, I will do my best to try and answer them. But while I think we'll go ahead to the next slide where you can download materials, including your certificate, your carefully crafted LEU certificate. And be sure and type your name in that before you print it out. That's the only part of the certificate that should be accessible, but there is a little highlighted space for your name. And And here's also the Patron Code of Conduct if you didn't get that before. Also, unless you just registered last night or this morning, you should have in your inbox a email from me that includes the Patron Code of Conduct and my my PowerPoint materials. So, great. I think that's it. Thank you so much for your time and attention and your very good questions.